So what is a father? At what point do you become liable for child support? And what would happen now if a man were to make a similar kind of agreement with a friend? Well, Lara Vitjens is Chief Executive of the National Gamete Donation Trust. Natalie Gamble is a lawyer who specialises in the issues surrounding fertility treatments and joins us from Southampton. Natalie, what does the law say about the position of someone like Mark?
Well, the law is very black and white, and essentially if you're the biological father, then you are financially responsible unless you fall within one of the very clearly defined categories of being a legal sperm donor. And those are that you have either donated your sperm through a licensed clinic, or that you have donated to a couple who are either a married couple or nowadays also a lesbian couple who are civil partners. And if you don't fall into any of those categories, you are the legal father and you're financially responsible.
Lara, how many more cases do you reckon there may be like this one?
There are thousands of cases of people who have donated this way or have received this way, but when it comes to relationship breakdown, which ultimately this is, we have no idea.
So Natalie, if someone like Mark did exactly the same thing now, making a private arrangement, no lawyer involved at all, just nothing written down at all, what would his position be now?
Well, it would depend entirely on the status of the people he donates to. So if he would donate to a lesbian couple who were in a civil partnership, then they would both be the legal parents of the child. So they would share financial responsibility and he wouldn't have any responsibilities at all. If he were to donate to a lesbian couple who were not in a civil partnership, then the position would be the same unless the donation had happened through a licensed clinic, which, as Mark said quite rightly, is possible now in a way that it wasn't 13 years ago.
Well, now, civil partnerships, Natalie, were introduced in 2004.
Mm-hmm.
The law was changed, as you say, in 2009. How likely is it for Mark to get some sort of retrospective amendment?
Well, I mean, it's very difficult because obviously any retrospective amendment is going to affect a lot of people who kind of went into arrangements on the basis of a different law. And our law here, you know, in other countries they have law which defines parentage based on what people intend at the outset, but we've never taken that approach here. We have kind of quite clearly defined rules about who the parents are. And so it would be quite difficult, I think, to amend our existing law because it would create a situation potentially where anybody who's a biological father could say, well, I'm not responsible because I was just acting as a donor. So there need to be quite clear boundaries. And, you know, the boundaries that have been agreed are the ones that I've just been describing. And it would be, I think, difficult to apply that retrospectively unless we change the whole framework, so it's kind of on the basis of what people are agreeing at the outset. But again, then it would have to be very clear what was agreed. There would have to be some kind of formal agreement, I'm sure.
Lara, what impact could this case coming to prominence have on future donations?
As Natalie says, I think it's highly unlikely that they will change the law because so many cases are involved. But what will happen is, I hope so anyway, that it's a warning for people who intend to use a sperm donor, or indeed sperm donors, to seek legal advice and be absolutely sure how they do it. The best is still going via a licensed clinic, because then you can absolutely sure about not just the legal status of the donor and indeed the children who the parents are, but also some medical checks and genetic tests, which clearly with an informal arrangement as this is not happening. And it protects the patients as well, because the reverse case could also be true, and we've seen that happening, is that donors actually then want to have access. They, from the outset, they think they don't want access to the children, all of a sudden feel that there's a connection there, then go to the mother, and the patients actually find that they're in a position that they don't want to be in.
Why, though? I mean, people must be aware that there may be complications that can arise from this, and yet people are still doing it. They're still making informal arrangements.
Yeah,
why?
I don't understand. I mean, you mentioned the word naivety. That's ultimately what it is as well. Relationships between people do break down, and what I find astonishing is that you need a signature for a library card nowadays, but just because it's an easy process, especially with informal donation, it can be done easily, of course. People take it lightly.
Well, as Mark explained.
Well, absolutely, and because it's done so easily, and you can do it, in the privacy of your own home, people take it very lightly, and that's something we need to warn people about.
How conscious, Natalie, are you of people still doing it informally, and what's your theory as to why they might do it?
I think there are lots of reasons why people do it. I mean, sometimes it's to do with the cost of going through a fertility clinic. Sometimes it's because if people are in a lesbian relationship or they're single, they don't actually feel they have a medical condition and they need medical treatment. And sometimes it's because people want to know more about the donor than would be possible through a clinic, and perhaps for him to even have some involvement. And we deal with a huge number of private sperm donation arrangements, and it's probably worth saying that these kinds of cases where things go horribly wrong are not a big proportion of them. That are, a lot of people go into arrangements and everything actually works very well. And as long as everyone remains in agreement, the legal issues that are underlying it don't necessarily cause a problem. But there is a risk if you go into things without the protection of the law. So I think the most important thing is for people, if they choose to do that for any of those reasons I've just mentioned, are very clear about what the law is that is underpinning their situation. So they understand that if, people fall out, then things could go very horribly pear-shaped.
So just to reiterate, if a couple came to you, not a couple, but a man and a woman who wanted to do this but were not a couple, what would you say absolutely vitally they must do before embarking on an informal arrangement?
Well, it all hinges on what you've done before conception. So if you want to have a situation where the donor is not the legal father, you either the couple need to register as civil partners if they're in a lesbian relationship, or everybody needs to go to a clinic and register and deal with the conception there. It's also a good idea to put in place an agreement, or at least think about the kinds of issues around what kind of roles everyone's going to play, and is the donor going to be involved in any way, so that there is absolute clarity about how things are going to work. I mean, as Laura mentioned, we deal with cases as well where things have gone wrong because the donor actually wants more involvement than the mothers are happy with. And in those situations, it's really important to make sure everybody's clear about what everybody wants, because if there are mismatched expectations, it can be a recipe for disaster.
Natalie Gamble and Laura Vitchins, thank you both very much indeed for being with us.